morning. My name is Christian West Coleman. I'm here on behalf of Appellant Memphis Shelby County Schools, or MSCS, and I would like to reserve 2 minutes for rebuttal.
2 minutes? All right, you may proceed.
All right, so as brief factual background, appellee was involved in a motor vehicle accident on November 13th, 2020 with Jewel Dockery, a male truck driver for MSCS. Mr. Dockery unfortunately passed away not long after this accident for unrelated reasons. Appellee in this action did file an expert disclosure that listed a Dr. Rance Wilborn as both a treating physician and a Rule 26 expert. Appellee disclosed the substance of this expert's testimony by referring to the topics discussed in Dr. Wilborn's deposition that had been taken previously. At trial, appellee failed to elicit any testimony about Jewel Dockery or his position at MSCS. Also during trial, MSCS raised and briefed many objections about Dr. Wilborn's and Dr. Sunita Jain's expert testimony. At the close of appellee's proof, MSCS raised a motion for involuntary dismissal for appellee's failure to put forth any proof that Jewel Dockery can be considered an employee that is qualified to lift governmental immunity as defined by the Governmental Tort Liability Act in Section 2920-107A.
Didn't your client file an answer admitting all those things?
Well, Your Honor, my client filed an answer in response to plaintiff's complaint, which alleged that Mr. Dockery was employed by MSCS and at the time of the accident was operating a motor vehicle owned by MSCS.
And your client admitted that?
Yes, my client admitted that. However,
why does that not end the discussion?
Well, because 2920-107A requires more than just those two factors to consider a person an employee.
You're telling me that if you admit something in an answer, you admit an allegation, and if you are defending and a complaint's filed against you, and you admit those allegations in the answer itself, without any reservation, that then the opposing party has to go further and prove that again at trial?
Well, Your Honor, that's not what I'm stating here. 2920-107A has 5 facts that must be established. We admitted 1 and 4.
If you admitted it in the answer?
Your Honor, we did not admit it in the answer. We admitted
you just told me you did.
We admitted 1 and 4 of those 5 elements.
You admitted that this person was an employee, correct?
Your Honor, I admitted that he was employed by MSCS.
What's the difference?
Not an employee as defined by the GTLA.
What's the difference?
I will explain that. Thank you, Your Honor. 107.
Please do.
2920-107A requires courts to make 5 specific findings of fact before considering a person an employee that can lift governmental immunity. That's 5 factors that go beyond the common law definition of employee that was essentially admitted in this action. So those 5.
Do you have any law that supports what you're saying?
Yes, Your Honor. The statute states that.
No. Do you have any case law that supports what you're saying?
That supports that those 5 elements have to be shown?
That supports that if you have admitted that the person is an employee, that then the opposing party must then go back and prove they're an employee.
I do not have case law that states that, but that is not what happened in this case. Your Honor, there are 5 elements.
I understand what you're saying.
The 5 elements are, 1,
I understand.
That the governmental entity selected and engaged.
Counsel,
that means,
I suggest you move on.
well, Your Honor, MSCS admitted 1 and 4 of these 5 elements. The other 3 in regard to payment of compensation from payroll, entitlement to the same benefits and insurance as the rest of persons employed by MSCS, and entitlement to grievance procedures, none of those things are in the record in this case. The GTLA is in derogation of the common law. Therefore, plaintiffs have a high burden, strict compliance to abide by those 5 requirements and put those things in the record. An admission that one is employed, which is one engaged and selected by the governmental entity, and that the employee was using the vehicle of MSCS only meets elements 1 and 4 of those 5. So it is our position that we did not admit, we only admitted what was asked of us, which is that he was employed or hired, which is number 1, and that he was driving our vehicle, which is number 4. There are 3 more elements that this legislature decided to make a requirement of plaintiffs to prove, and they're just not in the record. In my normal practice, many plaintiffs put in their complaint this and allege that the individual is an employee as defined by 107A, and I happily admit that. But in this circumstance, where the plaintiff is the master of his complaint, he did not include definitions that said that all these terms are to be defined by the 107 by the GTLA. There was no mention of 107A at all, and there was no mention of the word employee in the complaint or at the trial of this action. So it is our position that at no point was there an admission that all 5 elements required to be shown by the plaintiff and specifically found by the court were in this record. And so there are many cases cited in my brief as it relates to this issue and how courts do go through this process of going through and finding these 5 elements in the record before considering an individual to be an employee as defined by the GTLA.
And those cases that you cite are those where the defendant has already admitted that the person was an employee?
No, Your Honor, but that's not what happened in this case either.
I'm sorry, when you say that's not what happened in this case, tell me specifically what do you mean? Because from the answer, it was admitted that he was employed and that he was operating that vehicle owned by the school system in the course of his employment at the time of the accident. So what do you say was not admitted? And also, and I think you've been asked this question before, do you have any case law that says that when you make those admissions that the plaintiff still has to put on further proof concerning the factors that you outlined?
No, Your Honor, I can see that I have not come across a case in which those factors are admitted and the plaintiff has to put on that proof. But again, those factors, 5 factors were not admitted. They're not in the record. And so those, to be employed just qualifies number 1, that you were hired and that the governmental entity itself selected and engaged the person in question. That's what employed means. So that's number 1 of the 5.
So you think when y'all admitted that he was employed, it did not mean that he was an employee?
Right.
Or you don't think that saying that he was employed, that it's implicit in that that person was an employee of the school system?
No, Your Honor, because the statute one can very well be an employee of the school district, but if their compensation does not come from payroll or is paid by grant funds, then that person cannot be considered an employee for the purposes of this statute. One can be an employee, but are you the right type of employee to lift governmental immunity is the question. And there's no proof of that here.
Did you cite any case in your brief that makes the distinction that you're making now that we can look at and determine whether that supports the position that you're arguing this morning?
Well, Your Honor, again, I don't have any cases on point in which they're dealing with an admission. Most of the cases are going to be brought by, at least in my research, are brought by individuals who were sued in their individual capacity and are trying to prove that they are an employee. That's where these cases most frequently come up. But in the cases that I cited in my brief do state that the court, Williamson versus Regional One Health, Baker versus Nidegger, these courts, and Braylon versus, let's see. These courts do go through these 5 steps to determine if a person is an employee as defined by the GTLA. Because the term employee at common law is different from the legal definition of the term under the statute. And the statute requires more than just has a person been hired, and is a person acting within the scope of their employment. It's just black letter, plain in the text of the statute. And there's nothing in the statute that says that there are any special circumstances to consider, or that this has to be in dispute, or that, or anything, that an admission of 1 or 2 of those factors is sufficient to carry the weight of all 5 of those factors. Those things have to be proven in the record, and the court has to specifically find. To find otherwise means that that statute is totally non-effective. That you don't have to show all 5 of those things, and only 2 of those things were admitted in this case. In addition, the trial court erred in admitting opinions of Dr. Rance Wilborn that were not disclosed in appellee's supplementary expert disclosure. As I stated earlier, Dr. Wilborn was mentioned in appellee's supplemental disclosure. However, his opinions, the substance of those opinions, were linked to a deposition that he had, in which, after 15 months of treating the appellee, he stated that he had not seen any of her medical records during that time in treatment, and that he had not reviewed bills from 8 other providers. And so, however, at the time of trial, he stated that those 8 other providers' treatment and costs were necessary and reasonable. And so he was tendered as a treating physician, and the substance of his testimony was linked to a deposition in which he stated he had not viewed those records during his treatment. He viewed those records cramming to review subpoenaed records for trial. And so under 2605 of Tennessee Rules of Procedure, he should have been disclosed.
Well, when you first started your argument, you said that he was disclosed first as a treating physician and as an expert. And if you look at the discovery in this case, they indicate, in response to your questions about an expert, they said that he would be testifying as a treating physician, and also they would ask questions of him as an expert. And at the time of trial, from my reading of the transcript, he was tendered as both a treating physician and also as an expert, and the school board didn't lodge any objection to him being tendered as an expert.
Where, Your Honor, the school district lodged objections to his testimony that delved beyond his treatment of the...
Well, that's what experts can do. And then at trial, when tendered as an expert, there was no objection.
Well, at trial, we were not aware of what he would be testifying to, because again, in his disclosure, a month before trial, he linked his testimony at trial, the substance of it, to his deposition. And so though they disclosed him as an expert, they said that the substance would be everything that he knew at his deposition. And in his deposition, he stated at that time that he did not review these medical records of these other providers or their bills. So they weren't gained during treatment, and they weren't properly disclosed because the substance was not spelled out in that, in their disclosure. Their substance, they just relied on that deposition, and that deposition only limited his testimony to his care and the ER care. Those are the two things he knew about in that deposition. So anything beyond that should have been disclosed thoroughly. The substance should have been disclosed in his expert disclosures, and they were not.
And he did testify at trial, is that right?
Yes, Your Honor.
Okay, all right.
Thank you. Hear from the appellee.
I'm sorry.
I said we'll hear from the appellee.
Thank you, Honors, and good morning. My name is Louis Lyons, and may it please the court, I have the privilege of representing Miss Marilyn Butcher and her late husband and his estate, Ron Butcher. Unless the court has any questions about the facts of the underlying accident or the ensuing medical treatment that Miss Butcher received for her mild traumatic brain injury and cervical injuries, we'll get straight to the legal issues in the case. The first of which we'd like to address is the GTLA removal of immunity. And we submit that the court need not even delve into statutory construction to resolve the issue because it turns on the proper legal standard under a Rule 41 motion for involuntary dismissal and the appropriate standard of review under Rule 13D of the Rules of Appellate Procedure, as well as the burden of proof that a plaintiff must meet in a GTLL case. A motion, so the question is, does, in a non-jury civil case like this one, are the trial court's findings of fact that are correct? Under the rules, they're presumed to be by this court unless the evidence preponderates otherwise. So, does the evidence preponderate against the trial court's finding that Jewel Dockery was an employee of the school board? It does not. The board argued below, as it does here, that plaintiff has the burden to establish the 5 elements at 2920-107, even when the government admits in its answer multiple times that the person is an employee and acting within the scope of his employment. Implicit in the trial court's denial of the board's motion for involuntary dismissal was its finding that the plaintiff established a prima facie case that Mr. Dockery was the board's employee. It did. The burden then shifts to the defendant to establish that he was not, because the admissions, being judicial admissions, which are binding, and they were unequivocal in this case, they were repeated, and they were absolute. There was no qualification.
Were there any reservations to them?
No, Your Honor. And the board, this is an important point, the board, just like anyone else, is charged with knowledge of the legislative code, okay? The TCA, the board knew what it is, what it says, and it says to be considered an employee of a governmental entity for the purposes of the GTLA, that the 1 through 5 have to be established. Well, they knew that when they admitted that he was an employee. And in this case, had they desired to hold the plaintiff to prove those factors, they would have done in any of the hundreds of answers that I've filed in my career, say, denied, and we demand strict proof thereof. That's what pleadings are for, to frame the issues.
So you're saying there was an implicit finding by the court that this individual satisfied the elements of the statute of 292107?
Yes, Your Honor. I mean, and that's maybe even doing a disservice to Judge Smith, because her ruling was clear on the issue and noted, and I'm reading for the findings of fact and conclusions of law, that the plaintiff failed, that the board's argument was that plaintiff failed to prove that Mr. Dockery was an employee, period. The board admitted he was an employee. Therefore, we established a prima facie case, and the court went on to find that based on the answer filed by the defendant, where it admitted that Mr. Dockery was employed by the school board and was acting in the course of his, in scope of his employment at that time, that was, because of the standard under Rule 41, the court necessarily found that was sufficient to establish a prima facie case that he was an employee sufficient to support a finding that sovereign immunity was removed.
And so if you look at Section A, your opposing counsel argues Section A of the statute and the factors there, and Section A says that any person who is not elected or appointed official or a member of a board, agency, or commission shall not be considered an employee of a governmental entity for purposes of this chapter unless the court specifically finds that all of the following elements exist, and then it lists 1 through 5. So you're saying that what the judge did there in the order satisfied this portion of the statute?
Yes, Your Honor. And that's simply because it says we shall not be considered an employee, and I'm paraphrasing, for the purposes of the GTLA, or removing immunity thereunder. Shall not be considered is a subjective, that's the subjective voice. The board considered him the employee when they admitted that he was their employee and that he was employed by them and acting within the course and scope of employment. So they considered him an employee, and they knew that those elements had to be met. Now, keep in mind also, so at that point, we say we establish the prima facie case, the burden then shifts. And the court has addressed this before in a case that we did not cite in our brief, but I found recently, and that's Winford versus Hiawassee Apartment Complex, 812 Southwest 2nd, 293, a 1991 Tennessee Court of Appeals opinion. This court held, now this was a common law question about whether a person was an employee or an independent contractor or an employee of another party. But the court held that when a prima facie case is made by the plaintiff that a person is an employee, then the burden of going forward with evidence to the contrary is on the defendant. There's no reason that same rule should not apply in this context, because the complaint was, in this case, was clearly brought pursuant to the Governmental Tort Liability Act. The GTLA was cited multiple times in the complaint, and the defendant, it was alleged that the defendant was a governmental entity under the GTLA. So to suggest that the complaint was only alleging a common law definition of an employee is disingenuous, because it was clearly, and this court has previously found, for instance, in the Spearman decision that I believe Judge McGee authored, the court found there was no dispute that that employee there was an employee of the school board, and it was the same what we have here, the same allegations, the same answer, and there were no specific findings under TCA 2920-107A. Because it wasn't indisputed, and it wasn't disputed because the school board admitted it.
If you want us to consider that authority, you'll need to file it as supplemental authority.
The Hiawassee case?
Yes.
We'll be happy to do that, Your Honor, and I apologize for not including it previously. By way of analogy on this point, if in a common law case, if you allege that one is an employee of another without alleging the factors that courts consider, because that's all that the elements in TCA 107A state. These are the elements that the court must find to establish an employment.
So let me ask you this then. When it says shall not be considered an employee of a governmental entity for the purposes of this chapter, what is for the purposes of this chapter? Why is that there?
Well, that's a good question, Your Honor. And the definitions, there is a definitions section of that chapter, which is TCA, we cited it in our brief, but it is TCA 2920-102, and the lead into that section says, as used in this chapter, unless the context otherwise requires, and then number 2, parent number 2, employee, means and includes any official, officer, employee, or servant, and again, I'm omitting some of the operative words, or employee or servant of a governmental entity, including the sheriff and the sheriff's employees, and further members of voluntary firefighters, et cetera. And there's another section that's important, and it says that, and that is 2920, I'm sorry, I may have misspoke earlier. The definitions section is 2920-102. Paren 2 under that section is where it defines employee. 2920-202 is the section that specifically removes immunity for car accident cases. And there it says, immunity from suit of all governmental entities is removed for injuries resulting from the negligent operation by any employee of a motor vehicle or other equipment while in the scope of employment. And it's in reliance on those definitions, 2920-202, 2920-102, that we submit that the court properly found, and if not expressly, at least tacitly, that Mr. Dockery was an employee for the purposes of removing sovereign immunity, sufficient to establish a prima facie case on the point, and it was up to the defendant to then present evidence that he did not satisfy any of those elements in 107A.
Well, if you look at 2920-202, does 2920-107 even matter?
We submit that it does not, Your Honor. In the cases that have addressed 2920-107A and the subsequent subparts of Section 107 have all been in the context of healthcare liability cases, and that's important because the case that we just heard, there's a lot of moving pieces in that context, and people work at different hospitals, they have different privileges, they're employed by different folks. All of the cases where any court of appeals in this state, in any of the sections, or the Supreme Court has addressed it, it has been where an individual seeks to claim immunity where none should be afforded, or the converse of that, where an entity seeks to claim immunity for someone that doesn't, who is not their employee. And we address all those cases in our brief, Your Honor, regarding the distinction. And in this case, again, we go back to the fact that the board unequivocally, multiple times, in its own pleadings, not just in the answer, but in briefs filed and right before trial. This case is about an accident that involved our employee, Jewel Dockery. Those were their words in their brief. That wasn't even a response to anything. And that gets us to the point that even if this court finds error with the trial court's lack of findings of fact under 107, the error is harmless. There is no showing of any prejudice by the fact that those facts weren't established. The board has not taken the position that that those elements aren't true. There is, in such a case, and the basis of why statutes tend to say we're going to require specific findings of fact, in all the cases cited by the board in their principal brief were, I believe all of them, were parental rights, termination of parental rights cases, where this court well knows that the specific findings that are required by statute to be made have got to be made by the trial court in order for this court to have any meaningful review. Applying that same logic to this, the basis of the trial court's ruling as to why while the court below found sovereign immunity was removed, was clear. It was their answer and the position that they took throughout trial. And there was evidence at trial adduced, in addition to testimony from one of the responding officers that said that Mr. Dockery was employed by the school board. There was we filed a motion in limine, and it was admitted after trial, a statement that says, name the employee involved in the accident, Jewel Dockery. So there was additional evidence to support that. Unless my time is drawing close, unless the court has any other questions, we would want to touch on some of the other issues, but I'm happy to answer any questions on the GTLA issue if the court has any. With respect to Dr. Wilburn, he was a treating physician. He testified live at trial. The school board took his deposition more than a year before he testified at trial. He was disclosed as a treating physician out of an abundance of caution, to the extent that he might offer any opinions that could potentially be deemed, not that we deemed him that way, but just in case, to clear up any confusion, we did an additional disclosure. That disclosure says that he is not specifically retained as an expert, to the extent that any of his opinions transcend the permissible scope for non-retained treating physicians. We'll designate him as an expert. He's expected to testify regarding the past and ongoing treatment and diagnosis of Ms. Butcher. And he testified that at the time of trial, he was still treating her. He has treated her since, and he was treating her up until, I think he saw her almost a few weeks before he testified at trial. We did reference his discovery deposition for a more detailed description, and I'm quoting, of the substance of the facts and opinions, and we will incorporate that, period. Further, his testimony will be based on his own examination of Ms. Butcher, her medical records, medical bills, and history. He did exactly what treating physicians do in every personal injury case, and that is testify consistent with his training, education, and experience, his physical examination of the patient, and his diagnosis and treatment recommendations. He also testified consistent with Long versus Madeley and its progeny, including more recent cases that we've cited in our brief. The Long versus Madeley rule applies to Dr. Wilburn and it applies to Dr. Jane, and they both provided sufficient testimony to meet plaintiff's burden of proof, and the trial court should be affirmed. Thank you.
Thank you.
Sir, just briefly in response to some of Appellee's arguments. Again, the school board, in its answer, did not admit that Mr. Dockery was an employee as defined by the DTLA. Again, we admitted what was asked, which is number 1 and number 4 of the 2920-107A. However, we did not use the term employee in the answer, did not use the term employee at the trial. And we also raised the affirmative defense of immunity in the answer. And in later motions in limine, when we did use the term employee, we also followed in the next sentence by saying that that he is not an employee that can, we do not admit that he's the appropriate type of employee to raise vicarious liability against the school district.
And at trial, did you put on any proof in regard to these other factors that you say were not met?
Your Honor,
did you put in anything for the court's consideration to make a determination that he was not an employee acting within the course and scope of his employment as you admitted in your answer?
Again, Your Honor, we did not admit that he was an employee in our answer.
All right, in your answer, you admitted that he was employed and that at the time of the accident, he was acting in the course and scope of his employment. Now, my question is, in regard to these other factors that you say were not met, did you put on any proof to show that those factors were not met in this case?
No, Your Honor, because the burden is on the plaintiff. The case that he cited, the Windsor case, states common law, and this is derogation of common law. We don't have the burden to do that. Plaintiff did not put, appellee did not put any of that proof in the record, despite having discovery from staff and opportunity to have the trial. He didn't enter any of that in the record, and it is not our burden under the DTLA, not the common law, as appellee mentioned, for us to put on any proof. We just responded to what was asked of us from the appellee. And it's a high burden when you derogate the common law. The statute requires these 5 elements, and appellee didn't put any of that proof in the record. It's not our burden.
Yeah, I may have asked you this earlier. Do you have a single case that you can cite where a defendant employer admits in the answer that a person is employed, and at the time of the accident, they're acting within the course and scope of his employment, you have a case that says that that's insufficient for purposes of a GTLA claim,
No,
that
Your
the
Honor.
plaintiff has to put on more?
No, Your Honor, I don't have a case where all 5 of those elements have been admitted, but those elements have not been admitted in this case. There's no case out there, and that doesn't apply to this case either, because those 5 elements were not admitted at any point.
Okay.
All right, thank you. Thank you, counsel. We will take this matter under advisement, attempt to get you an opinion at the earliest possible time. You may be excused. Thank you. Ms. Angie,